Well, you had a bunch of other important dissents in a series of cases involving business interests. And these are technical but crucial. There's a lot of money at stake, and more importantly, there's a question of whether people can sue in federal court for remedies of federal statutes or can file class actions. Why don't you tell us about those cases and what was at stake and why you dissented quite forcefully?
So I think the case that you're talking about is a case called American Express, and it started in an antitrust suit brought by a small restaurant owner against American Express, saying that American Express had engaged in an illegal tying arrangement, trying to tie one of their products on which they had a monopoly to a broader swath of business. And the question really was this merchant going to be able to bring suit, because there was not much in it for this single merchant. Maybe it was going to get $10,000 or $20,000. And so this merchant was going to have to combine with other merchants, and maybe through a class action, maybe through other devices to share costs, in order to have any kind of effective means of bringing suit and of vindicating the antitrust laws. And the question was how easy we were going to make that for people, or how hard it was. And the court, and this was a decision that's followed quite a number of other decisions, made it very difficult, made the ability to bring class actions or to share costs in other ways across a number of individuals or a number of small businesses, made that very difficult. And it affects access to the courts, and it affects the ability really to bring large businesses, to hold them accountable for violations of law, both federal and state. And it's an important issue going forward.
Is this a pro-business court?
Well, none of us decide cases based on who the parties are. It's not like the Chamber of Commerce appears in court and you vote, I like the Chamber of Commerce or I don't. Or a consumer appears in court and you say, I think consumers need more protection or they don't. I think people look at the individual cases before them. But I do think that in a number of cases, with respect to a number of areas of law, there is a majority of the court that has a set of legal views that provide some significant relief from both federal and state regulation to businesses. So if you look at just even the last couple of weeks of the term, there were a couple of cases in which the court very restrictively read anti-discrimination laws, made it harder to bring anti-discrimination suits. There was another case where the court made it harder for local governments to put conditions on development permits. For example, to say that a developer ought to do environmental mitigation of some kinds. There was another case where where the court made it harder for injured plaintiffs who have had terrible reactions to various kinds of pharmaceutical drugs to sue for injury. So I think there were a number of cases where the court made it more difficult for injured persons to come to court and to use federal and state law to hold business to account for injuries that they've done.